Hello and welcome to another Substance on Substance. I'm Phil Graham, Head of the Economic Substance Analysis at Harneys in the BVI, joined by Josh Mangeot.
Welcome back, Phil.
Thank you. He has stepped away from the chairman's chair. He's back in his appropriate role, and obviously good to be here. I've returned from a trip actually over to Zurich, where it was fascinating to hear some of the insights from users of BVI vehicles over there, and actually a general sort of very high level of understanding, which was fantastic, and had a thoroughly enjoyable time discussing some of the nuances of this legislation. One of the things we wanted to get into today was really to discuss two aspects. The first aspect was the recent adoption of the statutory legislation, and frankly looking at the October 1st date, which there are a variety of sort of scurrilous rumours floating around October 1 and what that means, and really to hammer that home with Josh as to what it actually does mean. And then secondly, Josh and our colleague George Weston have just run out of a really interesting presentation to the local Association of Registered Agents, and to really touch on some of the topics that Josh was talking about there. So without further ado, let me start on October 1, Josh. What is this date? Should people be worried? What should people be looking at? Where does it come from?
Thanks, yeah, and while Phil's been in Zurich, I've been merrily chipping away at the coalface, and this is a question that keeps coming up, is what does the 1st of October date mean? Effectively, under the amended beneficial ownership legislation, there is an ongoing obligation on every corporate and legal entity, as defined, even if they are going to claim non-resident status, to be exempt from the substance requirements, to identify whether or not they have any relevant activities, and if so, which ones, and some other new kind of less key information. So that is there to bolster effectively the compliance periods for economic substance, which have started for all entities, and really to reinforce the fact this is something that the company needs to be thinking about now. That is not a reporting requirement. You need to be thinking about this requirement. The information will get sent to the registered agent on a backwards-looking basis in 2020 generally. The one exception to that is if you were previously an exempt person under BOS. Those exempt persons, if they carry on any relevant activity, will cease to be exempt, and they will need to be reporting beneficial ownership information. The time frame for that reporting is 15 days from identifying the beneficial owner or the change. So, subject to that one wrinkle, this is very much a 2020 problem for registered agents to think about, but it's a 2019 problem for companies to think about.
Now, to ask a sort of interesting academic question without wanting to set sort of wild hairs running, Josh, some people have said to us, well, okay, technically, does that mean that the ITA could come in now to an entity and say, from October 1, you should have been thinking about this. It's very clear that you should have been thinking about this. Whilst you haven't reported yet, because you have no obligation to do so, please demonstrate to us that you are thinking about it.
And so the investigation power generally is in respect to financial periods that end on or after the 31st of December this year. So the way we're reading that, I think, is effectively that they can investigate you for this period. But that said, it is highly unlikely that at this point in time they're going to be coming out and investigating people's compliance, particularly given the issues that we've had around timing of implementation and the publication of their final rules. Really, the message is you need to be thinking about your compliance position now and your status and classifying yourselves if you haven't already, and then effectively putting in place the information that you're going to be able to submit to your registered agent to discharge your reporting obligations next year.
And do you think on that basis that if someone, for example, an entity decided right at the end of the period to start thinking about this for the first time, or even worse, right at the end of their reporting period, sort of 6 months after the end of their first period, started to think about it then and put something in place, is there a risk that even if they put something in place at that point in time, the ITA can come back and say, well, hang on a sec, from October 1, you should have been thinking about this. Why on earth did you leave it so late?
Yeah, theoretically, that's the kind of the nightmare position that we're trying to prepare people against, to get and think about this now and to start building, their resolutions and their minute book out to record, if they took advice, what that advice said, how they fall out under legislation, or if they haven't taken advice and they're doing this themselves, then what was the basis of your decision making? In theory, if you've got to the end of the compliance period and effectively it's the first time you've thought about it, then yes, there is a criminal offence now under BOSS, which is worth being aware of, particularly if you're a director of an entity, for example. And we've kind of already talked about in the last session. The last thing I just wanted to pick up on that we were discussing with the ARA really has to do with this exercise that we think entities should be going through now of creating, kind of what their reporting is going to look like effectively, of putting in place their minute book and gathering the information that falls out of their position under the legislation. So whether that's evidence that they're tax resident somewhere else currently under that expanded concept under Part 4 of the rules, or that they're out of scope of the rules entirely because of their activities, or that they're a pure equity holding entity, in which case it's quite simple against us determining that and being prepared to report, or that they had to do something more substantial, then if you have taken legal advice in doing that exercise, it's important to remember that will be privileged in the hands of the person that it's addressed to, as long as they've come to the law firm that's given it kind of with clean hands and given them all the information that the lawyer needed to do that classification exercise or give that advice. That's important to remember as we start to think about reporting, because people may want to give that to their registered agent or show that to their professional directors to kind of reassure them that this is something we've thought about, you've discharged your duties, the RA has just taken reasonable steps to gather the information and make sure that's correct. When you're doing that, remember that advice is privileged, and make it clear that that's given on a confidential basis. It's not being given to the world at large when you do that. It's being delivered for a specific purpose to the RA, whoever it is. And the RAs then need to be thinking about, we may be holding clients' privileged information at this point on our files. So the headline point is the world at large is not entitled to this. If a regulator comes along and asks you to give up the information you hold, you need to remembering, is this legal advice privilege, and escalating it accordingly, either back to the client or internally.
I think that's a great point, and it's incredibly important. The protection, the confidentiality of information here is so important to so many clients. And there is a sort of ongoing concern around this area that what this is doing is opening up sort of an information flow, and I think that point around legal privilege is a really important one that Josh raises. Anything else that came out of your talk? Any interesting questions that you had today?
So we had an interesting one about, as I should say, interesting in this context. It's quite a dry one, but it's definitely one for registered agents and licensees to be thinking about. Is first of all the interaction with the changes to the regulatory code that we've had coming through, which are really bolstering the compliance responsibilities of BVI licensees, and also around record keeping requirements and kind of GDPR and how that interrelates. And I think that the headline message is the general look back period that the ITA has under this legislation is 6 years from the end of the financial period, unless there's some kind of greater impropriety, in which case it's unlimited. So that's actually building out the length of time that licensees and companies need to be keeping their books and records for, because generally the rule is 5 years under the BCA and other legislation. So six years from the end of the financial period is probably the general rule.
Very interesting, as always, Josh.
Thank you very much.
Cheers.
Bye.